Hello, everyone, and welcome to Uncivil Law. I hope you're having a good day. For those of you who are coming over from our earlier stream from Supreme Court React, we did something dealing with whether or not a pipeline was going to be built under the Appalachian Trail. Hello, everyone, and welcome to Uncivil Law. I hope you're having a good day. And we concluded after listening to the oral argument that, or at least I concluded, I won't speak for everyone, I concluded that there was a pretty decent chance that it was going to be reversed by some votes of a very fractionated nature. Didn't know exactly who was going to be voting for what and didn't know how much and all that good stuff. So I'm going to quickly post this link in Discord. All right, so now it's in Discord for the people who want to go from there. And we're going to listen to the oral argument from Jorge Baez-Sanchez versus William Barr. We read the case. Yes, there is a Discord. If you see in my little description of the video, and on most videos, there's a little link to all the places you can follow me. And I am on the Lawful Masses Discord under the name of Blackleaf. That's a place you can go and follow me. So yay. Yes, the Supreme Court does have a motion for reconsideration. I can't remember any time it's ever been successful, but it is on the books, and can't remember a time it's ever been granted, but I'm sure it's happened. The link is in the description of this title of this video. If you look in the description of this video, there's a link to it. Follow Uncivil Law on Facebook. Follow Uncivil Law on Twitter. Follow Uncivil Law on Discord. Follow Uncivil Law on Twitch. So it's in the description of this video. That's how you can find it. Until I get more popular and start my own Discord. So until I get more popular and start my own Discord, that is what we're doing. And we're continuing to enjoy my new apartment in Texas. So there's no video for this because it's Court of Appeals. It's just audio. So I suppose what I'll do is I'll just keep my wonderful visage up, and you can enjoy that in all of its glory. And we will listen to this audio and see what's going on. Sorry I stopped commenting, a little bit there at the end. But I don't know about any of you, but at some point when that guy was talking, I stopped caring about my interest in his problem. I comment where I did, and it's like, we'll finish it out. But it's like, I just cannot, whether or not it's fair or not, whether or not it's due to medical condition or not, people judge people based on a whole bunch of things. And as an oral advocate, that voice, not as good as mine. I'd like to respectfully argue. I have my own problems, but that vocal tonality is not one of them. So, yeah, this case was decided, as a matter of fact. The Seventh Circuit Court of Appeals destroyed the Bureau, destroyed the Immigration Court. Destroyed them. So for those of you who don't remember what happened in this case, there was an illegal alien, citizen of Mexico. He was convicted of a crime that made him deportable. He asked for a waiver from the Attorney General and asked for a visa from Homeland Security? ? The Attorney General, of course, doesn't consider these things directly. He's the head of the immigration judges, so his power has been transferred to the judges. The trial judge said, yes, I'm going to grant this waiver. On what basis, I don't know, nor is it important for our story. But trial judge says yes. The Board of Appeals, not to be confused with the Court of Appeals, but the internal board said, consider again. The trial judge said yes. I think they said consider again. They said yes. The board said no. We don't think you have the authority to do this at all. Then it got appealed to the Seventh Circuit Court of Appeals. The Seventh Circuit said, We think you do have authority, and here's some questions we want you to consider. And then the board just blatantly ignored the Court of Appeals. And then it went back to the Court of Appeals after being blatantly ignored. So this is oral argument take 2, Electric Boogaloo, wherein they are being destroyed for ignoring the court. And this was argued on 115, and the decision already came around. It was only 5 pages, so it's not that big a surprise. But we're going to listen to the court get a. There's no video. No, there's no video for the decision. There's no video for the decision. There's no transcript or anything like that. So all we have is the audio, which is nothing, but that's what we have. So we're going to listen to this. Yeah, that's the facts of the case. So let us listen to this, and let's listen to the government's attorney argue why it was totally cool for the administrative board to ignore the Court of Appeals. This should be good.
Our next case this morning is Baez-Sanchez against Barr.
Good morning. My name is Mr. Zachary Avalon, and I'm here on behalf of the petitioner, Mr. Baez-Sanchez. The last time this case was here, this court held that immigration judges have the power to issue waivers of inadmissibility to U visa applicants pursuant to 8 U.S.C. 1182 D3A2. But the court remanded back to the Board of Immigration Appeals and gave it a chance to consider 2 additional arguments that were raised for the first time on appeal by the government attorneys. But on remand, that's not what the board did. Instead, the board expressly disagreed with the holdings of this court and held that immigration judges do not have the authority to issue waivers of inadmissibility to U visa applicants. The board did not base its conclusions on any new analysis, just repeated that it disagreed with the holdings of this court and grounded its decisions on reasoning that this court has already explicitly rejected. And that should make this a very easy case.
Mr. Avalon, let me ask you, the immigration judge, as I understand it in this case, has twice granted this waiver of inadmissibility, is that right?
That's correct.
There was an initial remand for applying a more stringent standard?
That's correct, Your Honor.
That remand would certainly seem to have implied that the board thought that the IJ had the power to do that.
Can you hear it?
The board has been very inconsistent in applying that.
At this point, is there any issue on the merits of the immigration judge's exercise of discretion to grant that waiver of inadmissibility?
I'm not aware of any, and I do not believe that the government raised any.
Only after the second IJ decision, there's only been discussion about the power to do it at all?
I believe
The IJ would be the immigration judge, which is a bureaucratic official. It's not a court, but yeah.
on the remand from this court down to the board during that proceeding, the court or the government raised no other issues.
Where I'm going with this is that, as you know, in administrative law cases, the ordinary remedy is to remand to the agency for a fresh decision. But in rare cases where agencies are intransigent and there's really no issue, sometimes courts will simply order the relief directly. If we were to do that, would that be more than you'd want to defend, or an overreach, or would that be appropriate at this point in this case?
Your Honor,
So you got to love that question as an advocate, right? You got to love that question as an advocate, right? Like, normally, we just send this back down. But, there have been rare occasions when they've been so intransigent, we just directly rule. So what do you think? Would you be cool? Would you be cool with it if we just, from our own initiative, just ruled for your client directly, like right now? Would that be okay with you if we just gave you a direct win right here, right now? Yes, that would be great. I'd like one win, please, to go. That'd be great. Oh man, he he's trying to be clever. Well, it's the judge speaking right now, not the advocate. So the judge is allowed to try to be clever. So
Frankly, we have not considered that in depth. I believe we'd be happy with that result. We would also be happy with.
Well, what Judge Hamilton was asking was, are you going to be happy when you submit the brief in opposition to the petition for certiorari,
if we do
saying
that.
we have engaged in ultra vires conduct?
So yeah, that's they're thinking ahead, right? It's like, are you gonna be happy when we get a brief, because ultra vires is beyond power? So are you gonna be happy when we do this, and they complain to our bosses that we did something beyond our power? I don't really see the U.S. Supreme Court getting involved in this one. I mean, it's not a ridiculous question, but it's like, oh. The Supreme Court is going to look at this and be like, "Oh, they blatantly ignored the Seventh Circuit. Go to hell." I mean, but so I don't think it's going to be much of a petition, but yeah, sure.
We'd be happy to defend this court in the Supreme Court as well. Absolutely. And so, as I mentioned, this should make this.
I think at that point, really, if you're smarter. And I don't blame him for not being, because it would be hard. But at that point, I'd be like, well, if there's nothing further, I'm just going to sit down now. It's like, I'm only 3 minutes into this. I've got 15. It's only a 21-minute argument. So I'm guessing both sides didn't use their full 15, since it's only 21 minutes instead of 30. But it's like, if I'm the judge at this point, I'm half tempted to be like, how about you just sit down and let's destroy your counsel for the remaining amount of time. How about that? Be like, that'd be good. That's fine. I'm just going to sit down out and let you do that. That'd be great. Oh, man.
Easy case. Under both the laws of the circuit and the law of the case, the board's decision is plainly wrong and must be vacated. And in fact, the government agrees that the board's decision below cannot stand.
I don't think it's fair to say that they agree that it cannot stand. They have just asked us to remand to consider a total.
Melanie 16040 asks, what is the case? Man, I explained the whole thing on the introduction, but there was a guy, there was a petition. The Board of Immigration Appeals in the Department of Justice ignored the Seventh Circuit Court of Appeals. And now they're back up. The Seventh Circuit said do stuff. And the board said, no, we think you're wrong on the law. And now we're back up to the Seventh Circuit. So the Seventh Circuit now has to decide whether or not it was okay for the Department of Justice to ignore the Seventh Circuit Court of Appeals. That is fundamentally the issue at this point. And the decision already came out. The answer is new. Very much new. It's just an issue of how miserable do we want to make the government's life? That's the only real question. How much pain do we want to inflict? Yeah, that's what we're listening to. That's the oral argument. Well, the decision has come down, but we're going back in time.
Irrelevancy, which is how much deference does the board think we ought to give it? Since we're the only ones who can decide how much deference to give to the board's view on that question is neither here nor there. The thing that's interesting, at least to me, but we'll be asking Mr. Tennyson about this, is the failure of the Attorney General to...
As a lawyer, I'd like to believe that I'd take on just about any case and fight for any clause. But man, this one, I don't know. What am I gonna do? How do I argue this with a straight face? Okay, how do I make an argument that it was okay how do I make the argument to the Seventh Circuit that it was okay for the board to ignore the Seventh Circuit? Fight Marbury versus Madison? I don't know.
defend any of the board's reasoning. I mean, you've accurately observed that they're not defending the board, but I don't think it's fair to say they've confessed error on the board either.
Well, they explicitly said that there was no error, but they were refusing to acknowledge that the board's, or they seem to recognize that the board's decision, because it's not afforded any deference and provided no additional reasoning, they seem to make a calculated decision that it is unlikely to be affirmed here in this court. And that's why they seem to want to remand without, or they've explicitly asked for a remand without any instructions whatsoever, in hopes that the board will reach the same decision again next time, but perhaps in an opinion, in a format that might be afforded more deference. But the court should deny that request, just like it denied the first request that the government made for remand. Because
there is no deny stamp big enough for what I would want to do as a judge. There's no stamp big enough for no, this is not happening. I just can't wait to hear what the government has to say. I want to see if they come up with anything. Now I think we all have to lower our expectations way down when it comes to the government side, because they've got a hard try. So we're going to see if there's anything that doesn't pass the laugh test, and we're going to have to adjust our standards way the hell down to not pass that bar, just like as a matter of course. So we're going to try really hard as a team to just try to see if there's anything at all the government says that makes any sense on any level. That's the challenge. Okay.
the government's request has no basis in law. According to the government's argument, under the Supreme Court's recent decision in Kaiser, it is too soon for this court to review this final agency action because the board's opinion is, in the government's own words, not thoroughly reasoned and not fully cooked. In other words, as you mentioned, the government takes the extraordinary position that when a reviewing court encounters final agency action that is not authoritative or well-reasoned, that Kaiser requires the court to remand back down to the board to allow the agency to try again and come up with better reasons or more authoritative opinion. But the government's argument is...
The agency could have done that on its own. The Attorney General on his own motion can review any decision of the board. I take it that wasn't done here.
That was... If your question is...
We remanded for the board to do two particular things. It chose not to do those things.
That's correct.
I take it the Attorney General could have glommed onto the case and said, okay, I'm going to do those two things. And here's the answer.
I believe that the government's probably best suited to answer that question, but I'm unaware of any regulations that would have prevented the Attorney General.
Right.
Either the office that's litigating this case
I
or
know.
the Attorney General.
There's a sense in which I'm asking you a question that Mr. Tennyson needs to address. You're not the Attorney General's keeper. That much we understand.
That is true. And just to make it clear, what we're asking for the court to do is to remand back to the board with specific instructions that immigration judges do have the authority to issue these waivers of inadmissibility. And neither Kaiser nor any other case supports the government's novel effort here to secure yet another do-over in hopes that the next time the board will come up with better reasons or a more authoritative explanation for its refusal to adhere to this court's precedent. And if there are no further questions, I'll reserve the balance.
Mm-hmm. Certainly, Mr. Avalone.
He used 7.5 of his 15 minutes, but really he should have used half of that. Really, when they said, would you have any objection to us just like ruling for you? He should have been like, yeah, I'm done. I'm good. Now, I don't blame him. Like, I would probably not do that. I don't really have the experience to do that. But, if he had the experience and he had the cojones, he should have just sat down. It's 3.5 minutes. He didn't need 7.5. But, he at least didn't use his full 15. So we'll give him points where points are due. So we've got, so we used 7.5 minutes, and there's 21 minutes left. So or 21 minutes total. I apologize. 21 minutes total. So for the math people in the room, that means that they're about to use all the 15 minutes, basically, and beat this guy to death. This should be entertaining. Ah, good times.
Well, Mr. Tennyson, I'm sure you would have been happier if the board had addressed on remand the two questions we laid out for the board.
Oh, yes.
But, so why haven't you filed a confession of error?
Okay, so confession of error is, as the name suggests, is basically saying we screwed up. It's saying we won, but we screwed up. I've seen it done at the Supreme Court level from time to time by the Attorney General, where they say we screwed where we want the level below, but we shouldn't have. So that's a confession of error. I suppose a private party could do it. I've never heard of one by a private party, but I suppose there's no reason that you couldn't file a confession of error and just be like, yeah, we can see that we shouldn't have won the case. So he's asking, why didn't you just file a concession of error? Because you should have. Because you clearly were wrong. So what answer do you have for this?
I believe the answer to that is that, and this court in Wren has allowed us to without confessing error.
Do you hear how he just swallowed his words? I believe this court has said in Wren has allowed without confessing error. He drops it. He drops his voice. That's called swallowing your words, or that's another way of calling it. When you like utter something really low, it's basically like, I know I'm guilty, so I'm going to bring my voice down. I believe this court has allowed us in this case, without confessing error. But he's basically like, he won't say it full voice because he's too ashamed. Yeah, it's what we would call a tell.
Go back and
But this
where
case
further.
This case already went back.
Sure.
It went back with instructions to do two things, although in the board's view, doing one or the other would suffice without needing to do both. The board chose to do neither. We don't have a rule of endless remands. Usually one remand to do it right should be quite sufficient.
Right. I think there are a couple of reasons why. First off, just broadly, under a Gary, there is, we do want to be sensitive to the foreign policy concerns and
Indeed, there are very good reasons why the Secretary of Homeland Security might be the right person to make this decision. And of course, the government argued the last time the case was here that was so. And we said, but this depends on regulations which haven't been discussed. And given pretty old rules from the 1940s of administrative law, we have to rely on the board's reasoning or none at all. So we do the required thing of sending it to the board. And the board chooses to give us the bird. What are we supposed to do next?
Right. I would say give them a second chance with maybe stronger instructions.
They've had a second chance.
Ooh. Man, they've given us the bird. What should we do? And he's like, maybe give him a second chance with better instructions.
With stronger instructions.
Stronger instructions?
With
something
clear instructions. I mean,
unclear about
very
the
clear
previous
sort of
opinion,
statement.
counsel?
Perhaps give them a roadmap where they, I think...
Clearer
What
than
is
the
this?
previous opinion?
I think that it's clearer than the previous opinion.
How could you be clearer than that opinion?
Let me take a different approach, Mr. Tennyson. Let me go back to the question that I asked Mr. Avalon. The immigration judge here has twice, under two different standards, found a waiver of inadmissibility appropriate for Mr. Baez-Sanchez. If the immigration judge had the power to do that, does the board or the Department of Justice have any other objection to that decision?
I believe that's a Ventura question. I think there might be other eligibility questions, questions of the application of deference.
Have any of those were any of those raised in any of the prior appeals to the board?
The board, the DHS did raise it in its appeal of the immigration judge's second decision, if I remember correctly.
Do we have that in our record?
What?
Do we have that in our record?
It should be in your record, Your Honor. So there would be, so under Ventura, there is reason to send it back. Even if the authority question is settled, the eligibility question, the discretionary question with regard to discretionary issues, and say that they ultimately find that he does get a waiver. The consequences of that waiver are still things that the board has to resolve.
In
so
what
there's
way?
Still stuff for the board to do.
In what way?
One, there is an eligibility question as to what kinds of what.
Were any of those issues raised when the immigration judge first granted the waiver of inadmissibility?
I think in the initial appeal, there were questions. I think the primary issue that DHS raised was the discretionary one in the appropriate discretionary standard.
Mm-hmm.
And I think the same thing occurred with regard to the application of that discretionary standard in the second appeal. I don't think that the board has addressed, because it's denied the waiver multiple times, what the consequences of granting the waiver would be. So there are those sorts of issues that are still outstanding.
I'm thinking about cases we see a pattern fairly often. For example, there will be a criminal conviction. There will be an appeal, let's say, of a sentencing issue.
Right.
There will be a remand,
Right.
a new sentence, and then the defendant will raise new issues on appeal, challenging the validity of his guilty plea or a trial issue. And we treat all those issues as having been waived by failure to raise them in the first appeal. I wonder does the board have similar procedural rules?
Right, of waiving issue with DHS. Mm-hmm. Especially considering you would see it come up in the exhaustion cases that the Seventh Circuit gets, where the board just addresses things that DHS doesn't raise, or that the petitioner doesn't raise. So there may be, the board does sometimes treat certain claims as waived, but often it addresses them anyway, and those cases get exhausted and come here. Those issues get exhausted and come here. But let me try and go back to, I think those issues should, at least the board should definitely have again, should have the opportunity to address on remand. With regard to the first set of issues, the authority.
If that happens, you understand that a subsequent appeal will come to the three of us.
Yes, Your Honor. So
you can make that clear.
I'm hoping that we get a decision that I'm more than happy to defend up here. Yes, Your Honor.
So it's the same panel. It doesn't go to a different panel because it's part of the same continuing thing. So when it gets sent back down, whether it gets sent back down to the same trial judge or the same whatever, and when it goes back up as part of the same process, it gets heard by the same panel that heard it originally. It's sometimes called a one horse, one rider. But it's that idea that the same people handle it, so that you don't get crosstalk, because a different panel of judges could come out differently. It's like, well, you drew this panel, so sucks to be you. That's now your reality.
I'm more than happy to defend up here. Yes, Your Honor. If that happens, the petitioner could very well prevail, in which case,
that would simplify a lot.
Yes, it
it'd be nice to, I love seeing you guys.
It's only a waiver of inadmissibility.
Right.
So what else did you want to tell us?
But going back to the adjudication question, there are reasons why the board should be allowed to go again.
You hear that again? He swallows his words. There are reasons the board should be allowed to go again. He does that again. He's dipping below, swallowing his words. He doesn't actually believe what he's saying, because he's not communicating with force. He's dipping below. So when he comes to it, he's swallowing his words. So that's a tell. He doesn't believe it. He knows he's talking crap. And he's not hiding that he knows he's talking crap. So, yeah.
In addition to the sort of the broad foreign policy issue raised in Giri, there are particular issues with regard to the construction of the statute and the regulations that have further consequences within the INA or within the agency's operations. The determination of the term Attorney General, particularly after the Homeland Security Act, how that plays out is, and
We address.
Yeah, someone asked the question that we can actually answer. Yes. So Melanie 16040 says, so basically when you appeal, you raise everything possible so as to preserve the issues. Yes. With very few exceptions, you don't bring it, you lose it. If you're at trial, you don't make the objection, you lose it. If you don't raise it on the appeal, you lose it. Most issues are waived. So if you don't bring it, you lose it. And that's one of the things that they basically said in the decision as well. They said, well, they're like all these other issues, but they weren't brought up in this appeal, so they're dead to us. So they're dead to us, and we're not going to consider them. There are exceptions. The most notable exception to that is subject matter jurisdiction. So if a court can't consider an issue because it's outside their subject matter, that's something that can be raised fresh at any time, on any level. I've actually seen it done at the U.S. Supreme Court level, where the Supreme Court themselves has raised the issue about subject matter jurisdiction. So that's the most notable example. If something was beyond a court's power, then basically it never happened, right? Because the court wasn't able to hear it. But yeah, most of the time, you don't use it, you lose it.
We addressed that in our first opinion.
yes, Your Honor.
We said the statute transfers particular powers to the Secretary and not others. And whether others are transferred depends on regulations and potentially a presidentially issued reorganization plan. Okay, so the board can address those questions. The board didn't, and you don't either.
Right, Your Honor.
Well,
I mean,
You hear that again, where he said "right, Your Honor." He said it was swallowed. He said "right, Your Honor." He said it, and he said it as a child being chastised. He said it was swallowing his words. He said it half. He didn't say it with conviction. He says it as a person being reprimanded. He doesn't believe what he's saying. So he's not a good poker player. He is showing his hand big time verbally. If you listen for it, you can hear it happen.
previously were skeptical.
what opportunity would the board have the third time that it didn't already have?
Melanie says, what issues does the Supreme Court not have jurisdiction over? Well, I'm so happy you asked me, Melanie, because I can answer your question. There are issues that are state law specific that the Supreme Court wouldn't have issue, because the Supreme Court only does federal law. And there's also issues with standing, would be examples, and that has actually come up this term, where they say, well, the person never had standing. If they didn't have standing, then there's no jurisdiction. So there's no, or the Supreme Court is not a court for original jurisdiction, except in some rare circumstances. So there's been some issues from time to time where someone has tried to appeal directly from an administrative agency directly to the Supreme Court, and you can't do that. You have to go through another court first. But yeah, it has happened from time to time where the Supreme Court has gone a case and they're like, oh yeah, we can't hear this because of various things. Yeah.
This is just simply asking to.
I know you're not the board, and it's unfair in a way, just as it was unfair to Mr. Avalone to ask some questions of him that belong to you. It's unfair to ask you questions that really go to the completely irresponsible behavior of the Board of Immigration Appeals, because they're not you.
Right.
But after they've behaved irresponsibly, it's very hard to ask the court to send it back in the hope that they will do better.
Right. Yes, right. I would sort of, in their defense, I think there's one intervening thing that occurred between this decision and their subsequent unpublished decision. The board issued Castrotum, and in Castrotum, the Attorney General, not the board, but the Attorney General issued Castrotum. And in that decision, the Attorney General disagreed with this court's decision in Baez-Sanchez, in this court's previous decision.
The Attorney General is entitled to his view.
Yes, Your Honor.
He can ask the Supreme Court to set aside our decision, though he didn't. He could ask the Supreme Court to set aside the next decision.
Yes, Your Honor.
But he can't just say, well, I disagree with the judicial decision, so I'm going to do something else. That's called contempt of court. And normally we don't think of the Attorney General as engaged in contempt.
Right.
But if that's his goal, there are remedies.
Right. I don't believe in Castrotum he was attempting to be to engage in contemptuous behavior. What I do think is that the board took the footnote and felt bound in some way by what the Attorney General had said in the footnote. By the Attorney General.
What was the issue in Castrotum?
Castrotum had to do with administrative closure, Your Honor, and whether or not
a little different from this issue.
It's completely different from this issue, but in footnote 6, the Attorney General addressed this case specifically with regard to.
Of course, there's nothing that we do that binds the Department of Justice to abandon its litigating position. But once a court decides a particular case, the decision has to be followed out, unless, of course, the Supreme Court reverses it. But as I've already said, the Attorney General did not seek certiorari from our decision.
Correct, Your Honor.
And there we are.
At best, I can try and explain what I think, where the board thought it was, and why it felt perhaps it was required to go the way it did. But
required by whom?
Well, they at least felt that, at least deemed that the Attorney General's decision in some way constrained the way in which they needed to approach this case afterwards.
Well, I do like his answer. It's the best situation, right? He's basically throwing the Attorney General under the bus because why not? Which is great, but he's throwing the Attorney General under the bus, so he's representing. I don't know, who technically is he representing at this point? I don't know. I guess technically he's representing the board, but he's throwing the AG under the bus in order to save the board. That's kind of cute. I like that. That's a good one.
And maybe giving them another chance and explaining, stating to them that that this court's decision means what it means.
I take it that the members of the board are attorneys.
Yes, Your Honor.
I'm very confident that the Attorney General is an attorney.
I would certainly hope
I
so.
don't think we are in the business of remanding to the board, telling them that the executive branch is free to have a litigating position, but has to obey decisions once rendered, at least in the particular case. Unlike many other judges, we have not purported to issue a nationwide injunction. Right? And Mendez, United States against Mendez, says that our holding does not bind the agency in other cases.
Right.
But it binds the agency in this case. And if the board members don't understand that, they need to go back to law school.
Yes, sir.
Oh, yes, sir. Oh, ouch. So for today's edition of Supreme Court React, we'll be reacting to Marbury versus Madison. This is like 1820 or whatever Supreme Court case. That'll be a good Supreme Court React. Let's react to Marbury versus Madison. Oh man, we're going all the way back. Okay.
All right. Well, if the court has no further questions, the government again, would request remand on the authority issue.
He's swallowing his request. He's swallowing his request for relief. He doesn't believe what he's saying. He doesn't believe it. He's swallowing his words and asking. We would ask that they reverse to the board to give him their chance. And I mean, oh my Lord, it's like, well, I just hope the judges buy him a drink later or something. It's like normally you buy someone a drink before you execute them, but I guess after will do just as well. Lord, jeez.
And certainly under Ventura, remand and all of the other remaining issues for them to consider in the first instance. Thank you.
Thank you, Mr. Tennyson, and I bet you will breathe a sigh of relief to be able to sit down. Anything further, Mr. Avalone?
Don't talk. Don't talk. Say no. Don't talk. Say no. Oh, say no.
I would just note I was surprised
He got up and said stuff. Oh, that was a mistake, but okay.
to hear the government discussing Castro-Tum, since that was not cited at all in their brief and never raised in defense of the board previously. And I would just reiterate our final request that we would ask the court remand with instructions to the board that it must follow the precedent of the circuit and confirm that the immigration judge does have the power to issue these waivers and that the board should thus adjudicate the case accordingly. That's it. Thank you.
Thank you very much. The case is taken under advisement.
I don't know to what degree the president can issue an executive order. I mean, for his U visa, it gets into whole territories of stuff, but yeah, presumably the president may be able to issue an executive order, but this goes into unitary executive theory. I'm not clear on the statute or regulations in terms of the president's ability to actually directly, at least by the letter of the statute or letter of the regulations, to directly issue an executive order with respect to the U visa. He may, but I'm not sure. But yeah, so that's good stuff. Do you think you could ask the Fed court to reconsider Marbury? Well, since Marbury is like the foundational case of federal court power, that's going to be a tough sell. But sure, why not? I'd like you to reconsider reverse Marbury. That's going to be a tough sell, but that's going to be entertaining. Yeah, as a try, I would not recommend giving it a shot. That would not be a recommended course of action. Yeah. Juan gives me MX $50, which I have no idea how much that is and what currency is that. It's $2.50 US, whatever it is. But thank you for the MX, maybe peso, Mexican peso, because of conversion rate. But thank you for the $2.50 US. It is, as always, appreciated. So yeah, he got destroyed, and that is the end of that. Yeah. So good times had by all. You can't. Well, no, that's true. You can deport naturalized persons. Well, you have to remove their citizenship before you can deport them. And as my memory is, and it's obviously not my field of law, but I think you can only reverse someone's naturalized citizenship for a lie they made on the paperwork for the citizenship itself. So if they made a lie on the citizenship paperwork, you can reverse their citizenship. I don't think you could deport them before you reverse their citizenship, and you have to show that that lie. But otherwise, I don't think naturalized citizenship can be reversed. And I know natural-born citizenship can't be. There was a U.S. Supreme Court case on that. You have more viewers than you do on Supreme Court Review. Yay! So I hope you're happy. Well, I like having viewers. Incidentally, I know this is a little far afield at the moment, but I did a live stream on Viva Fry's channel recently, and I talked about Vic Mignogna and the case involving Vic. And I have been, once again, fielding off comments of varying levels of scorn directed at me for my view on the Vic case. Some of them have been nice, and some of them have been decidedly not nice. You know, for those of you who have forgotten, Vic Mignogna, voice actor, did Broly, Dragon Ball Z. He's getting his butt kicked in Texas right now, and he's on appeal. And my view is he's going to lose. Now, that's a view as to what I think will happen, not as a view as to what I think should happen, which I think is part of the confusion on all this. I think some people are viewing my opinion as normative, like I'm saying this is what should occur. It's not normative. It's descriptive. I'm saying this is what I think will occur. You know, I'm merely describing or reporting. I'm not saying what I think should occur. But I've been fielding off. I've been fielding off the Vic fans. They are displeased with me because, you know, they're Vic fans and they want the case to come out for Vic. You know, my feelings one way or another as to how the case should come out are somewhat immaterial. You know, I'm neither. You know, I'm neither supporting nor opposing. I'm just trying to look at the legal analysis and come out with an opinion, you know, as it is. And so I've been dealing with that. But all that to say that I send an email to Rikita. For anyone who is watching this right now, I just want you to know I send an email to Nick Rikita tonight to ask him if he wants me to be on a stream. So if Nick says yes, I'll be happy to be on a stream. You know, I'm not wedded to my view on the Mignogna case. I'm not wedded to it. I'm reasonably well informed, but I'm certainly not as informed as Nick is or his fans are, and they are busting my chops on terminology too. They're really busting me. One guy busted me because I got the TCPA wrong. I said it was the Texas Citizens Protection Act, and it's this Texas Citizens Participation Act. So the fact that I misremember the acronym, well, that is a blow against my credibility. I'm like, you got to be kidding me. And I referred to the things that were attached to Vic's paperwork as depositions when they were actually declarations. And they were busting me over that. I'm like, you know, I understand there's a difference, but I don't think it turns on, my opinion turns on, you know, that they were actually declarations rather than depositions. I don't think that's the linchpin that's going to change my analysis, but I've been dealing with the haters of the Vic fans, and yeah, good stuff. Yeah, why has Vic been getting his butt kicked? At least in my humble view, and it depends who you ask. The Vic supporters think it's because the judge screwed up the case. I'm more of the view that it's Vic's lawyers who screwed up the case, and we have been in the comment thread arguing over various minutia over like what is and is not on the record, what was and is not considered, what is attached to what. If the judge, you know, improperly considered the standard because it's improper notice pleading, and if it's only, you know, the bare minimum amount of evidence that you need, and so like the Vic fans have been raking my opinion over the coals. It's been very unpleasant. The too long didn't read thing is. Apparently don't discuss the Vic Mignogna case unless you're going to tell the Vic Mignogna fans what they want to hear. What they want to hear is that their guy is going to win, which is, you know, perfectly reasonable. But whether or not he's going to win, I don't know. And they've been busting me. You know, one of them was on one of them yesterday on chat on VivaStream or the day before or whatever it was at this point, was saying, well, if you read the transcripts from the hearing, you'll realize the judge screwed up. And I had to say, no, I not only read those, I live stream reacted to those, and I don't agree. I don't think so. I thought that it was Vic's lawyers who screwed up. And then someone said, well, were you actually there? I'm like, Lord have mercy, man. There's nothing that makes these guys happy. Vic Mignogna, Vic Mignogna is a voiceover actor who was fired, and he is suing over defamation because there were allegations made very publicly that he had engaged in misconduct of potentially sexual nature, and he was suing for tortious interference. That's what the case was over. He was suing the people that wronged him, and I don't think he's going to win. I'm not saying whether or not I think he should win. I'm just saying, that's where it is. It's been a really interesting thing. So you go watch my short clip on Viva Frai's channel if you're so inclined, on describing it and discussing the case, and read the thing. And that was the Vic fans have been the Vic fans have been picking me apart because because what I would consider to be relatively little mistakes, right? I called it the Texas Citizens Protection Act rather than Texas Citizens Participation Act. This shows I'm incompetent. I called what was attached to Vic's filings depositions when they're actually declarations. This is what makes me incompetent, right? So making like little linguistic slips, or making like, I one time was talking about someone in the case. I think it was Monica's fiance, and I thought that at one point, oh, this is someone in the company. So I was talking about the privilege envelope, but like, no, this wasn't someone in the company. So I made like a slight factual mistake as to like who someone was in the case. Do I think any of that, like where I've been corrected on a lot of these things? Do I think any of these corrections are that big a deal? Not really. Do I think that they changed my analysis? Not really. I think the Vic fans are busting my chops over really small stuff. They're busting my chops over minutia. Because they think, like, I don't know what they think. They think it feels a little magic wordsy. It feels like, because I didn't use the right words, it feels like if I used the right words, I'd have the right opinion. It feels a little magic wordsy. So that's been entertaining. Yeah. And I said, for example, on Via Stream that it felt to me. I was very like explicit about emphasizing. It felt to me, or I think it was my language, or said like it appeared to me, or something like that. That Vic's lawyer didn't know about the TCPA. It was caught off guard, and someone said, "Well, that's not true. He knew all about it. It was just one they were going to file." I'm like, "Well, I just on the cold record of the page, it read that way to me. It read like he didn't know what was going on. It read to me like he was caught off guard. It read to me like he was trapped and he thought things were going to go on the back end." So like, yeah. Matt asked Kenny sue his attorney. To sue his attorney for malpractice, you'd have to basically show it would come out the other way. And I don't know that you can get there under Texas law either. Maybe. I think on the tortious interference stuff, possibly. But it depends on a lot of stuff. So, possibly, but I don't know they can necessarily win that argument either. Because lawyers get quite a lot of discretion and latitude. There's a lot of trial strategy things. Like, it's not really relevant to our immediate example, but, decisions to, like, call a witness or not. Decisions to introduce evidence or not. A lawyer can make strategic decisions. As long as those strategic decisions are, like, reasoned, you can't get him for malpractice. It's like, as long as he was trying to do it. And so, on the chance that on the chance of Vic's lawyer, whose name is Ty Beard, on the chance that Ty really did know about TCPA and he was doing things for a particular strategic or tactical reason, then he wouldn't be able to sue for malpractice. I can understand a rationale for why you would do things that way. I don't think that would be the right thing to do in this situation. The problem, in my view, was, at least in part, that he filed a bare bones notice pleading. As I've said many times, is it legal? Yes, you can do that. But I don't think it was the right decision in this instance. I think you should have tried to anticipate the counter arguments. And I said I was looking at Tulsi Gabbard's recent lawsuit against Hillary Clinton as an example, where Tulsi is attempting to preempt the arguments she knows is coming. She's attempting to address arguments that she knows are coming from Clinton before they ever happened. And I thought that was really good because, like, there's no reason not to do that because no one is being surprised, right? Like, it's not a surprise. We all know what's going to happen, and we all know what the responses are going to be. So why not save time? And it makes me look more competent. It just felt, I don't know, things felt not well done. That was my overall impression. And I didn't like the way that, he didn't seem to know what was going on, didn't seem to handle it. Yeah, and the Vic people are tearing this judge's life apart and are saying that this judge is routinely off the reservation and routinely not following process and blah blah blah. Maybe that's what is true, but I don't know that, and it looked okay. I mean, do I think there were mistakes that were made? Yeah, I think there were mistakes, but do I think you can get it reversed over it? Not really. Yeah. So I just, yeah. And the entire fight was over whether or not there should be a trial, right? So the entire thing was over not the prima facie case, right? The entire thing was over whether or not there was enough for a prima facie case. And that was a big criticism from the Vic supporters too. A lot of the Vic supporters were saying that the judge was effectively holding a trial where he was actually weighing the evidence versus only trying to see whether or not there was a prima facie case. So they're saying the judge didn't do a prima facie decision. He was doing effectively a trial decision. And I understand why the people who are watching that think that, but I think they're wrong. He was examining the evidence, yes, but at least from where I was sitting, it looked like a prima facie standard. It was exploratory, but that's okay as in a prima facie. You're still trying to see if you can get over the threshold. Now Nick Rakita has some pretty good counter arguments about this too, where he's there's some other things, but yeah. Winning appeal would let the trial happen, which would then be decided on merits. Well, it depends what the nature of the relief from the appeal court would be. Presumably, it would be, it wouldn't necessarily let the trial happen, but because the motion was to dismiss on the TCPA. So you would go back down to trial, presumably you'd go into discovery, and then you could have a motion for summary judgment, I would think. So you might not necessarily get to trial. It depends on the nature of the relief from the appeal court. But because there's, that's basically the problem. Well, that's at least the idea is that there wasn't enough to the controversy. The defamation stuff, the problem is okay, so there's a couple problems. On the defamation stuff, the defendants are saying, well, Vic did certain things to me. Vic is saying, no, I didn't do those things. And then Nick Rakita says, well, that makes it a case for controversy because they disagree. He would be right, but the problem is that Vic has been deemed a limited purpose public figure, which I think he is. I don't think the judge was wrong about that. So just because it's not enough that they disagree. You have to show the malice element. And I don't think that was well established on the pleadings, because the pleadings were treating it as though he weren't a public figure. So they didn't show the malice stuff to get past the public figure stuff. And when the judge ruled public figure, then they were caught flat-footed. And so Rakita says, well, Vic denies it, therefore there's a disagreement, therefore prima facie. I don't think that's right, because if you say that he's limited purpose public figure, then you have to actually show actual malice that isn't in the available evidence from pleadings. And so the prima facie case is not met once you've made that determination. And so that's, I don't think you make the prima facie case. On the tortious interference stuff, he didn't well list out which contracts. And the judge asked him what contracts. He didn't list them out. He didn't say like with bullet points what contracts there were. He kept referring to them very amorphously. And so it wasn't well specified. I think that's the technically correct term, right? To say it's when everything is spelled out like that. I think specified is the correct word, because I'm looking at it in a particular, very technical sense. I think specified is what I want. It wasn't well specified which exact contracts were interfered with, and the evidence for that. Some of the evidence for it were attached to the original declaration. The original declaration was struck down, because of a problem with the notarization. They tried to attach it to the second thing. The second thing was maybe denied entry, and so like all those declarations that would have shown evidence for the tortious interference don't seem to be on the record. And if it's not on the record, it didn't happen, and so therefore there's not pleading. So like, yeah, I'm still of the opinion that Vic can't get where he needs to be because he it just seems like it's screwed up. So that's what I think. Yeah. Malice seems to be assumed when you're calling someone a particular term. Remember, malice here is a term of art when you're talking about defamation law. Malice doesn't mean hatred. Malice in terms of defamation means malice to the truth. It means that you know it's false, or you should have known it's false. So malice doesn't mean I hate the guy. Malice means I know it's not true, or I should have known it's not true. So if someone was calling him that term, you would not have to, it's not that, oh, he hates me, because that's not the issue. The issue is when they uttered those words, they knew it was false or should have known it was false. And I don't think you can get there. And it wasn't on the pleadings. So malice is not assumed when you're using that term. It's defamation per se. You don't have to show damages. You don't have to show damages when you use that language. So you don't have to make the pleading of damages in that, but you still have to show that the falseness, that the knowledge of the falseness by the person who uttered it, and it wasn't well pleaded. So that's the problem. Yeah. If only two parties involved must go in plaintiff's favor, then defense lying under Kahn, Texas law, lying is malice. Okay, let me read that again, David. If only two parties involved, it must go in the plaintiff's favor. By defendant is lying. Lying is malice. Well, yes. It would be if you know it's not true, then yes, that would be malice. Malice is no knowledge of falseness, or you should have known. So if you know or should have known, then that's malice. A lie is when you say something that's knowingly false. That's what a lie is. So yes, that makes sense. That would be the case under the Kahn case. That makes sense. So yes, if you know you're lying, it's not just if you know you're lying, that means you know that what you're saying isn't true, which means that's malice, right? Because you have malice to the truth. So yes, if you can show the person was lying, in other words, they knew what they were saying was false, that would be what a lie is, right? If you know that, then yeah. But again, I don't think it was well pleaded. So yes, if they were lying, it would be actual malice because it would be with malice to the truth. But again, I don't think it was particularly well pleaded. So I don't think the Kahn case gets you where you want to be, because you still have to plead it. So I don't dispute that that's what Kahn says. I just don't think that, you're assuming it's a lie, and there wasn't anything there to establish that she knew it was a lie. There's nothing external, to show it was a lie. If she had ever said to anyone I know this isn't true, or I'm making this up, or if there was some external statement to reflect that she knew she was lying, then yeah. But there wasn't anything like that I saw on the record. So yeah, knowingly false is the same thing as a lie. So yeah, I don't have that. Sounds right. Okay, I'm on board with you. Yeah, that sounds right. Okay, I agree with you. Under Kahn, that qualifies malice. Sure. I don't think you're there. Surely there's no distinction between knowingly false and false? Yes, there is. Of course there is. Yes, there is, all the time. Just because you say something false doesn't mean that you know it's false. Yes, it is. I mean, it's hard for me to give an example, but because I would know that I'm making it up. But, I don't know. It's hard for me to come up with an example, but I could just say something and be mistaken. Or yeah, it's like I could say I'm hard pressed to think of an obvious example. let's pretend for a moment that I'm colorblind. So in this hypothetical world, I am now colorblind. Okay, premise. All right, great. This shirt is red. That would be false, but not knowingly false because I don't know it because I'm colorblind and I can't see it's green. There's an example. Okay, so now we're all on board. Yeah. Thank you for the encouragement. Thank you, Darth Lucas Lucifer, for the new encouragement on the new apartment. I am very much enjoying it. It's really good. They claim to know thing Isaac because they know thing that Isaac. I could be wrong about this, but I don't believe the Discord itself was on the record. That was another criticism of mine. I don't believe the Discord or any messages from it were ever submitted as evidence or pleaded. It would have been super helpful. There might very well be evidence on the Discord that would show it would be knowingly false. If there was evidence on the Discord that showed that they were knowingly making up lies, that would have been super helpful, Isaac. But to the best of my knowledge, the Discord was not on the record. So again, as far as the law is concerned, never happened because it's not on the record. No, this is my permanent new apartment. This is the real permanent apartment. This is the actual real permanent apartment. I got the new table, new lamp. You can see some fruit over there. I got my wine rack. I got Liberty and all that stuff. So yes, yeah. So if the Discord had evidence of them conspiring, which it would, because it's like there. If it had evidence of them making up stuff or deliberately like choosing to make up stuff, then yeah, you would have gone to malice easy. But I don't think the Discord was actually on the record. Yeah, so yeah, exactly, Hectic Gaming. It's not on the record. It's not on the record. If it's not on the record, it didn't happen. It doesn't exist. So, you know, that would have been really helpful evidence, but it's not there. All right, David Youngston says, let me go to Isaac first. I'm literally just going off your own streams right now. That included one of the women claiming he sniffed her hair. Right, but you'd have to show that like she knew that was a lie. Vic said, apologize. David says, because it was only Vic and Monica, and Vic and Jamie, under the TCPA, with the ruling of Kahn, Vic wins, as it's assumed on dispute of the facts, the plaintiff is right and the defendant is lying. Well, if that's what Kahn actually says, then you would be right. If Kahn actually says that you can presume the malice that you're needing to find, if it says that in a dispute between a one-on-one that you can presume the lie, which is the same thing as saying presume the malice, if you're able to do that, then yeah, you're there. Then yeah, you'd be right. Then the judge screwed up the case. If Kahn actually says that you can presume the malice, then you're right, and Vic should win. That would be a massive shift in the understanding of the law. So if Kahn really stands for the proposition that if there's a one-on-one and there's a he said she said, that you can presume the lie, you can presume the malice, then you're right. That would be a decisive case. If you can as a matter of law presume it for TCPA purposes, then the judge screwed up. Now, I have a slightly hard time believing that. I mean, because I've never read it, but I'd imagine that's not true. But if it is true, you win. You win. You know, I'm not moving goalposts over here. I'm not moving goalposts. So yeah, if Kahn says you can presume it, you win, and the judge screwed up. So I'll See if I can dig it. I don't suppose you happen to know the full name of the Kahn case. Do you happen to know the full name of it so I can pull it up on Westlaw? I'd imagine there's more than a few cases called Kahn. Do you happen to have the full name of it or the citation to it or something so I could read it? Let me see if I can find it. Maybe I can find it. Let's see if we can find it. I mean, I would be surprised if that's what it says, but if that's what it says. Matthew gave me a link. Is this what I need? Vanderlyn versus Kahn. Well, it looks suspiciously like what I need. Let's see. Let's do this as a, well, it's from Texas. What case is, who is this? Is this the Supreme Court of Texas? It looks like the Supreme Court of Texas. No, it's Court of Appeals for Fort Worth, but Court of Appeals is not nothing. I'll take a Court of Appeals decision. Let me pull this on OBS and we can read it together. Yeah, it's not Texas Supreme Court, but Court of Appeals is not nothing. And I assume that this is the right circuit for Texas law, but even if it's not, I'll take it. If it's not binding authority, it's persuasive authority. If it's even as persuasive authority, I'll concede the point. So let's see if it has what I need it to have. If I can get it up on the stream, that would be nice. There we go. All right, so let's see. I'm just going to download this PDF so I don't have to do... Oh, my Lord. Hold on. I'm not dealing with this on the screen the whole time. There we go. That's better. All right. And suddenly we have a new stream. This is for fraud, but would malice be similar? Maybe. But then you're reasoning by analogy. You know, obviously your best situation would be that this is a TCPA case. If it's not TCPA and it's fraud, then we're reasoning by analogy. So then you're not in a you win. You're in a more of a you might win. But let's see what it has to say, and let me give you my legal opinion as to how relevant I think it is or not to the issue. You know, I want to be an honest broker. I want to be an honest broker, and I want this to be a legal education channel. And I could be wrong. You know, I don't know every case everywhere, and I certainly don't know every judge everywhere. So, you know, let's read it. I'll try to give you what I think and do a legal analysis, right? Make the webcam look bigger. I was making it. Is that better? Or you want it like a little bit like this? So it's not quite more like this. Is that better? And I can do like this. All right. We're bringing an interlocutory appeal, denial, motion to dismiss, firm in part, revand in part, a board certified family physician, moved from Pakistan, complete residency. At the time of the lawsuit, chief executive of Tri-City. Vanderlyn is retired colonel. Her 24 years includes deployment. Vanderlyn and Kahn were neighbors. Vanderlyn said it's considered his wife. Okay. According to Vanderlyn, one evening when she and her husband were having dinner, she and Kahn engaged in private conversation about United States military presence. According to Vanderlyn, during the discussion, Kahn told her that he had given money to the Taliban. Vanderlyn described herself as shocked when Kahn said this, and she immediately questioned So why Kahn would do such a thing. Kahn's explanation, according to Vanderlyn, was his grandfather, who had worked in CIA, had relayed to him how the witnesses had flip-flopped with different administrations. Kahn denied this conversation ever took place. In his affidavit, further deposed that defies logic that he makes such a radical statement to a former colonel. Fair point. According to Vanderlyn, approximately 1 week later, she questioned Kahn again about why he donated money to a terrorist organization. During this conversation, Vanderlyn said she told him about a horrific event perpetrated by the Taliban, by the aftermath of which a friend of hers who had also been deployed had witnessed and later told her about. In reaction, Vanderlyn described as odd. Kahn allegedly responded to the story by saying the event was bad and really preferred animals over people. Well, not a unique sentiment, but yeah. If he passed an injured person versus a wounded animal, he rather stop for the animal. Again, not necessarily a unique sentiment, but yeah. Kahn also denied this conversation offer took place, pointed out he devoted his career to treating individuals. To your question, trademark, it has some state law. Copyright has a very little bit of state law still floating around, and patent is exclusively federal. Two conversations concerned her given the military career. Vanderlyn felt obliged to inform her what Kahn had told her about. Noticed one of the disputes waited more 5 months to act on this sense of duty. Okay. Sending the following message to Facebook accounts of Kahn. You're partnering with a Muslim who told me personally. Okay, so that sounds like suspiciously like this is defamation, right? So that sounds like it's going to be more on point than not. So that's a promising start for the it's on point. So we're talking about defamation, so that's nice. Okay. She received no response. The record is vague as how Vanderlyn obtained the names of Kahn's business associates. Vanderlyn became aware that Kahn had potential business venture pending with relatives. By looking at friends, she provided this for explanation. She had come to learn, I don't really care how they came to know about. That's not the issue. I don't care. I don't really care about our motives. Okay. At the time the message was sent, she had an oral agreement where Kahn would find a supplier to sell crude oil. The crude oil, Kahn would split. Okay, so Kahn has a business dealing. And further the agreement, Kahn has some more business dealing. In furtherance, in addition, Kahn has some more business dealings, but the deal did not go through. So we're looking at tortious interference, right? Okay. Kahn sued Vanderlyn for tortious interference with contract and prospective advantage. Well, okay. Vanderlyn sought dismissal of all the claims, denied motion to dismiss, brought interlocutory appeal, which she contends Kahn failed to meet the burden to establish prima facie. Okay, great. Texas civil remedies provide citizens from retaliatory lawsuits by the mechanism. Summary disposition is provided by blah, blah, blah. Dismissal involves a two-step process. The clear and specific evidentiary standard may be satisfied by direct or circumstantial evidence. We've seen that before. Supreme Court has directed us such evidence must be provided with some degree of detail. Okay, that makes sense. In the context of defamation, pleadings evidence that establish when, where, and what defamatory nature of statements, how they overcome the plaintiff should suffice to overcome a challenge. Okay. I see one problem here, though, that neither of these are public persons. It wouldn't appear. So I don't know that you're going to be able to get where you want to be, but I'll keep reading. We're directed to construe the statute liberally. Yes, it actually says that in the statute itself. I read that. Vanderlyn argues she met her burden of speech by showing TCP applies to the underlying lawsuit. First, he argues policy reasons are not present in this case. That's lame. That's not going to work. The policy reasons don't have to be. It's just as the statute applied. Bad argument. Vanderlyn has not met the burden to show the message was an exercise as defined. Thus, Kahn contends the law speech was not based. Kahn maintains the underlying policy requires us to make a determination. He suggests that if it's not brought, then he should not entitled to dismissal. I don't see that working, right? I don't think that's going to fly. We disagree. Yep, the court says we disagree. I do too. Yeah, I hadn't gotten that far yet, but I'm like, no, that's not going to fly. And then 3 sentences later, the court says, yeah, we disagree. I'm like, okay, yeah. When our goal in applying the statute is ascertain effect, so yeah, blah, blah, we look to the text. Yes, we do. If based on, relate to, now they're going to explain that it goes on the text. Freeze is obvious. It's related to safety and well-being. Yes, it is. Okay, that was easy. Because Vanderlyn does demonstrate that Kahn's implicated her exercise to prevent dismissal, Burns shifted to provide clear and specific. Okay. In her second issue, failed to meet the burden of establishing by clear and specific prima facie case for every essential element. We take each cause. Okay, tortious interference. Yeah. But it's probably going to be in the defamation section, but I'll keep reading everything to see what we have. To establish it, we must show you had valid contracts. Yeah. No clear and specific evidence of valid contracts. Yeah, I felt like this is a big problem for Vic on his tortious interference problem too. This is the same problem I see in in Vic's case for the TI issue. It was very vague to my mind in both the pleadings and the oral hearing what specific contracts, other than the one which got struck from the record because of the issues we talked about. But other than that one, there was nowhere where it said one, I would have literally done it as bullet points or numbered, one, Texas Con, this date, number 2, Kame Con, this date. I would have literally delineated them all. And it was very vague which contract. So the specificity for the TI was not there, in my humble opinion, in either the pleading or the response. The judge was basically saying what contracts, and Ty's response, in my humble opinion, was along the lines of, So that's how I feel about that. Evidence is too vague. Or the contract asserts they have valid contract, specifically indicated possible contract, failed to provide specific terms of contract or attach any contract or other memorialization. Yeah. So even if he had delineated them, at least as I understand it, this wasn't there either. There weren't, I was trying to allude to this in some of my prior streams, can I get emails from any of these guys? Can I get anything that shows the exact, can I show these expectations are rooted in something? Any email, a letter, a phone call, anything that show that these are rooted in some kind of reality. This is what it's talking about right here, where it says possibility versus there's nothing specific enough. So even if you delineate them, you still have to show specificity for each one, which could be emails or conversations or anything. But again, it wasn't on the record. So even if he delineated, I still think he fails here. No clear and specific evidence breach. You'd have to get a little bit more deep into the weeds as to ask whether or not there was a breach, particularly with the existing contracts. With the I'm not going to offer an opinion as to the existing contracts on breach, but I don't think you were there. And proximate cause, I think you can get there, but you weren't there. Could he still bring federal defamation? There's no federal defamation cause of action. A defamation is a state law claim. There's no federal defamation claim. Absent some federal interest, but there's no general federal statute that I can think of that would apply. Okay, then we're going to go to the exact statements. The objected to the statements hearing summarily overruled the hearsay. Witness testimony regarding what another person is thinking is speculation. Yes, is always speculation. So that would be nice if you had statements from them directly. So there's some hearsay stuff. And then I did my whole, this is not hearsay because it's not being offered for the purpose. Isn't there for employer-employee for defamation under federal law? I don't think so, Matt. But if you want to educate me about something, let me know. Causation, I think you could have gone there, but tortious interference, okay. Reasonable probability, independent tortious act, again, they're not well delineated. No clear and specific evidence would have occurred to prevent the relationship. Yeah. Record remains silent as to, it wasn't very well delineated, so I think that was a problem. No evidence of specific harm. Could have been a little bit better, but I think, again, I just don't think it was well spelled out. Yeah. Zekas, a claim should not be dismissed if the party bringing legal action establishes clear and specific evidence prima facie for each essential element of the claim in question. Yes, I agree with that. We're trying to determine whether or not that's true at the moment, and we're trying to find the issue dealing with the assumption of malice, because that was the reason the case was being cited to me, is that this case apparently stands for the proposition I can assume malice as part of the dispute. We haven't gone that far down because we're still in the tortious interference stuff, and the court is dealing with defamation further. But I figured I'd read the whole thing because, it's speaking to issues that are relevant to this, and so I'm commenting. But I actually haven't gone to the part that we actually came here for, which is, someone said, well, this Kahn case says that you can presume the falseness, or you can presume the lie, which is the same thing as saying malice. They're exactly the same thing. So I'm like, okay, if it says that, then you're basically, you win. You win. So I'm just trying to get to, well, we haven't gone that far yet, but I'm reading the case and analyzing because it has a lot of issues. I understand what notice pleading is. Yes, I understand. I understand. Zacchaeus, I understand. I've said this before, but I'll say it again. Yes, I understand notice pleading is legal. I'm not disputing it was legal. I just don't think it was particularly a good idea. And I don't think, I'm saying that, at least to my mind, it wasn't delineated. It certainly wasn't done in the pleading because it was notice pleading. It could have been, but it wasn't. Just because you can do notice pleading doesn't mean you should do notice pleading. And it wasn't delineated. It didn't have to be, you're right, but it wasn't. And it never became delineated any other time. It wasn't delineated in the oral argument either. So I never, at least to my mind, saw it really clearly specified. Maybe it does in some attachment to something I haven't seen yet. I saw the original complaint, the response, the TCPA, the response, and the oral hearing. I never saw it clearly specified. Maybe it is in some document somewhere. But so you're absolutely right. There's nothing wrong with filing a notice pleading on Texas. It's completely legal. You're absolutely 100% right. But you still have to make your case. You have to show the prima facie case of, the things. And you have to say what contracts at some point. And that didn't happen. It didn't even happen in the second amended petition, or second amended that I remember. He didn't even put it there. Again, he doesn't have to, but he has to do it at some point. It was never there. So, I don't think it was a good idea to do it the way he did. That's just my opinion. Defamation per se, publication of false statements, damages. Prove defamation must, but not the fourth. Yes. So when you're looking at defamation per se, again, statements dealing with sexual misconduct, sexual reputation, are a classic example of defamation per se. So you don't have to show damages. That's true, right? But we're interested in the falsity element because we're assuming the public figure. So we have to figure out, thinking of Section 43A of the Lanham Act, where a business is misrepresenting themselves, where the businesses, it's not, hold on. I'm now on a sidetrack. 43A of the Lanham Act. Yeah, false designation, false descriptions, and dilution. Yeah, so you can sue businesses for false marking of their goods, which isn't really defamation. It has to do with commercial speech, right? So you can't sell a product saying it does one thing and it doesn't do that thing. or like blatantly lying about your product. Yeah. That's not really defamation. That's false marketing, false stuff. But sure, I'm there with you. Okay. Falsity is per se. Well, Elon Musk had a trial, and the jury came out the way they did. So the jury didn't find it. So it's a classic example. There was a trial, and the jury found the way they found. So, will you say something about another business? Hold on. In commercial advertising, misrepresents the nature, characteristics, qualities, or geographic of his or her another person's goods. So yeah, if you blatantly mischaracterize someone else's goods, you're defaming. But you're not really defaming the person; you're defaming the product. But sure, Matthew, yes, that would be. Again, that's dealing with commercial speech, where you're diluting products. So it's not really defamation, but for analogy purposes, sure. Business disparagement and defamation are similar. Fair enough. I mean, it's similar conceptually, right? Like it makes sense to compare one to the other. So I'm on board comparing those two. That he denied that swearing. I never gave him. He also attempted to explain why Clinton should not be okay. Let me start that over and read it more carefully because I don't want to screw this up. Van der Linde claims that Kahn told her during a private discussion that he had given money to the Taliban. Kahn denied telling her that, swearing, "I never given money to the Taliban, nor did I tell her." In the affidavit, Kahn also attempted to explain why Van der Linde's claim should not be worthy of belief, urging it defies logic. Fine. The evidence Kahn offered was clear and specific. He had never given money to the Taliban, nor ever tell Van der Linde that he had. And as Van der Linde alleges, there were only two parties to this oral communication. Okay. And as Van der Linde alleges, there were only two parties to this oral communication. Kahn could hardly offer more to refute her claim. Thus, as to the first element, whether the message that Kahn had personally told her that he given money to Taliban was false. Kahn met his burden by establishing clear and specific prima facie evidence for a seminal element of falseness. Yes. Right. Falseness. But knowing falseness is the next thing. So the first element, falseness. He said, she said. So the first element is satisfied. Falseness, that it's false. That makes sense. Sure. So he says, she said, that's enough. I agree. Okay. The dissent argues if Kahn's statement did not tell Van der Linde gave the money, can suffice as clear and specific. Gave the money would suffice to meet the burden to prove the affirmative defense. The trial court was required to dismiss. The logic of the argument is appealing, but we also consider a common law, the falsity was presumed, and truth was affirmative defense. Sure. But in 1964, the Supreme Court changed. Now a case that implies constitutional issues. Case involves public official. Okay. Now when a case implicates constitutional issues, a case involves public official, media defendant, or matter of public concern, or in combination, the burden is on the plaintiff to prove falsity, not upon the defendant to prove truth. Right. That's where we need to be. The burden is upon the plaintiff to prove falsity in a case of public concern. That's where we need to be. Okay. In 1985, however, the Supreme Court breathed life back into affirmative defense of truth when it held that states like Texas could apply the common law to defamation actions that did not implicate the First Amendment, actions between private individuals and non-media persons. Right. In a regular defamation case, yes. Although the message here was part of private dispute between private and individual non-media, we also held the message was a private issue bearing of public concern. I'm having a hard time reading. It's getting a little late, and I'm having a tough time reading. So I'm just making sure that I'm reading this correctly because I don't want to misread it and give you a bad legal opinion. So that's why I'm taking my time. It's 11:35 my time, and I'm having a little trouble, and I just want to take my time and make sure I'm reading it correctly. 1985, however, the Supreme Court breathed life back into affirmative defense of truth when it held that states like Texas could apply the common law to defamation actions that did not implicate the First Amendment, actions between private individuals and non-media involving private issues. Sure. Although the message here was part of a private dispute, we also held the message was not private issue but public concern. Which the content of VIX could reasonably be viewed as public concern. Therefore, even considering the holding, the common law affirmative defense of truth wow, I'm having a tough time comprehending what this is trying to tell me. The common law affirmative defense of truth still does not apply. Thus, the common law principles do not apply, and Vanderlyn bears no ability to prove truth. Matt, what is this trying to tell me? Matt, you're a 1L. What is this trying to tell me? Kahn sued Vanderlyn. Kahn sued Vanderlyn in this case. So Kahn sued Vanderlyn. Truth would be an affirmative defense. Right, truth would be an affirmative defense. But she doesn't have to prove it's true. She doesn't have to prove it's true. Okay. Okay, if there were any remaining doubt on this point, the Supreme Court has recently addressed this identical argument. This is Texas Supreme Court, as you can tell from the citation, right? Not to mention the Southwest Third, and then it says Texas. So the Texas Supreme Court. If there are any remaining doubt on this point, the Supreme Court of Texas has recently addressed this identical argument. In D Magazine, the court held that on matters of public concern, the plaintiff bears the burden to prove falsity. So yeah, I'm still back where I started. I'm still back where I started because whether it's a matter of public concern or whether it's public figure, you're in the same exact position, right? The plaintiff bears the burden to prove the falsity. So I don't believe the Kahn case stands for the proposition you want to be. You can presume the statement is false for the first part of defamation claim. So you can presume it's false. But if you're a public figure or public matter, and arguably this is both, then you have to make the additional element of proving its falseness for the element of malice. So I believe, if I'm reading this correctly, and it is 11:37 at night, but I believe if I'm reading this correctly, the Kahn case agrees with what I was saying to you earlier. So I think I was right. So yeah. That's the way I'm reading this. The Supreme Court has rejected the argument that in a case involving a matter of public concern, once a plaintiff has met his burden to establish clear and specific evidence for falsity, the motion can be dismissed by proving evidence to the contrary. That makes sense. Okay. Because that makes sense, right? So, okay, then that makes sense. Now I understand the sentence from like before. Now I understand the sentence from before. It didn't make sense before, but now it makes sense in the context of this sentence. So what this is saying is the affirmative defense of truth is not available on the motion to dismiss. What this is saying is that the plaintiff has to, by clear and specific evidence, make the case for falsity. If he does that, you're done. Even if the defendant can show evidence for truth, doesn't matter, because now it's an issue of dispute of evidence, right? The plaintiff has made the prima facie case. So even if the defense can prove it's true or whatever, show evidence of its truth, it's irrelevant. It's irrelevant. The only thing you need, and that's what it was talking about when it was talking about the affirmative defense was not available. That's what it's talking about. Now it makes sense. The affirmative defense isn't available because truth isn't available, because it doesn't matter. All that the plaintiff has to show is its falseness. So the availability, so the truth as a affirmative defense is not available, because that would defeat the prima facie case. So I do not believe the Kahn case stands for the proposition you argued. I believe it stands for the proposition I argued. So I think you misread the Kahn case. I do not think. I think it says that Vic has to prove falsity or provide evidence of falsity. I think that's what that says. Vic has to provide clear and specific evidence of falsity. As long as you assume one of two things. As long as you assume one of two things, Vic is either a public figure or this is a matter of public concern. If one of those two things is true, then Vic has to provide clear and specific evidence it's false. And Monica cannot counter by arguing it's true. That's what that says. So this did not change my mind. I'm sorry. Thank you, Matt. My 1L also agrees with my reading. So yes. It was very weird, very weirdly written up here. But that's what it says, right? Now we understand. Thus, the common law principles do not apply. And Vanderlyn, this bears no burden to prove truth. That's what it was talking about. Now it makes sense. Strange sentence, but it makes sense once we read it further. So yes, unfortunately for the Vic fans out there, this case did not change my mind. This case is not a deviation from what I would have understood the law to be before we started. This is pretty typical. This doesn't reflect anything really strange to my mind. So sorry Vic fans, but I don't think the Kahn case is going to save you. So no. Yes, you can presume it's false for the first element of defamation. But if you're in public figure status or public concern status, no. Yeah. I don't know why the Discord is not in the record. The fact that the Discord is not in the record is unbelievable. It's unbelievable. It would have shown you your conspiracy and would have shown you everything you need. I mean, the Discord would have shown you everything you need. So, yeah. I think Vic is a public figure. It's a little hard for me to say he's not. Limited purpose, of course. But you can't be on panels and whatever they call them. What do they call them? Side, whatever they are. I forget. But you can't like be an invited guest for panels and sign autographs and take pictures and be in these breakout sessions was the word I was looking for. And breakout sessions. You can't do that for like years upon years upon years upon years and then say, oh, I'm not a public figure. It's like you're a little bit a public figure, man. I mean, you're kind of a little bit. And so like, yeah, I think you're there. I think you're there, a limited purpose public figure. A little hard to say, oh, look, he goes to all these things and people come to his things and they want his photograph and they want his signature and he has this huge fan base. I know he has a huge fan base because his fan base keep fighting me. So I'm pretty sure he's a limited purpose public figure because he has a fan base because they're fighting me. So yeah. So no, Kahn does not save you, Vic fans. Sorry, does not save you. All right, Melanie 16040. By the way, what does your name stand for? Because I can't figure it out. You'll have to help me out. Off topic, if defamation per se, and there's no debate or question made the statement, is a question of law as opposed to something for a fact finder to decide. Defamation per se means you don't have to show damages. Damages are presumed. So in your standard defamation case, you have to show it's false. You have to show publication that was said from one person to another. And that's about it, right? You have to show false, concerning someone else, publication, about that, right? And damages in your normal defamation case. In defamation per se, you don't have to show damages because damages are presumed. But you still have to show other things. As I understand it, the jury concluded that the tweets in question were not of and about the person in question. So they, it's essentially standing. It was basically what they broke down on. They said they weren't about the guy who sued them. The guy who sued Elon. They say they wasn't about him. Well, whether it's about him or not is a question of fact. So the jury said, well, it's not about him. Okay. Then, that's a question of fact. Is it about him or not? Apparently, no. Apparently, it was not about the guy who sued him. Don't ask me who it was about. They didn't ask the jury that question. And I don't know. But that was apparently the basis. It wasn't about the guy who sued. The wrong guy sued. Who should have sued? I don't know. Someone else, I guess. Yeah, that's my understanding of what happened in the jury case. It wasn't about him. It was about someone else. Okay. Yeah. That's what my understanding was. All right. Well, it is midnight, and I'm going to try to get some sleep, and then I'm going to try to start a normal day. If you have liked this, incidentally, I obviously won't require it, but for the Vic fans who have been holding my feet to the fire, and to whom I've been doing all this wonderful, diligent live streaming for, and looked up your case and read it with you and tried to understand it in detail to make sure that I was giving you the most correct opinion I possibly could. It would be nice if some of you guys would like to give me a super chat. I'm just saying, it would be nice to have some additional support. It's fun, but it's always nice to have some love. So, just FYI. And for the 43 of you who are watching this right now and have not given me a like, that would be nice too. So, yeah. Who the house number is, yeah, so I guess I don't get the all the Vic fans can subscribe now. Yeah. I guess I don't get the super chats from the Vic fans until I tell them what they want to hear. I I wish I could tell you what to hear. As you may have seen from some of my other content, if you watch anything else from my channel, I am more than a bit skeptical about all the Me Too stuff. I am more than a bit skeptical about all these claims. And I had that whole huge discussion with Tactical where some people were commenting about why are you having this discussion? It's but I'm skeptical of this. I do a lot of Title IX stuff for exactly that reason. I'm skeptical of it. So I also thought the claims against Vic were ridiculous. The claims were one time at a convention many years ago, he took a jelly bean that had the name Monica written on it, who was one of his coworkers, Monica Rial, or he wrote the name on the jelly bean, one of the two. And he said, look, and then he ate the jelly bean and said, look, I've eaten Monica. One jelly bean, one time at one convention 10 years ago or whatever. I'm you've got to be kidding me. The other one was he solicited a fan for a relationship. I'm not sure why that's relevant to anything. And the other one is he once consensually kissed a coworker. These are pretty lame claims. These are really lame claims. Thank you, David, for the £2. These are pretty stupid claims. We are tearing a guy's life apart for this. Really? He once ate a jelly bean that had someone's name on it and made a dad joke. Look, I've eaten Monica. Really? I mean, that's... So if we want to talk about Me Too and cancel culture and how poisonous and toxic it can be, the Vic fans will probably like me a lot more because I have many thoughts along those lines that will please the Vic fans, I'm sure. Because I think the whole thing was ridiculous. It's first of all, I don't want to infantilize women. I believe adult women should not be made into infants. They're not infantilicized. So, what's the problem from Vic asking a fan if they want to engage in some sort of romantic relationship? Unless we want to make women into infants. Are women not adults capable of making their own choices? I thought this was, women are equal. And they want to be treated as equals. So what's the problem? They're adult women, right? They're not infants. I don't want to infantilize them. He consensually kissed a coworker. Well, you had me at consent. I was informed by my brethren on the left that consent was all that mattered. So why are we talking about it? And I'm not even sure you can assume that eating the jelly bean was sexual. And even if it is, it's one jelly bean at one convention 10 years ago. Who cares? Who cares about any of this shit? It's total crap. It's total bizarro world. And the fact that what can only be described as a witch hunt against Vic was instigated over this crap. And based on this, that Funimation or whoever it was is tweeting, we don't tolerate XYZ, and oh, by the way, we fired Vic. And they're saying we know that Vic has 100 women against him and all that crap. The fact that it's another instance in cancel culture is a bunch of crap. Is a total bunch of crap, right? So even assuming everything that Monica and Funimation say is true, is crap. I think their investigation was crap. I think the reasons for it was crap. I think firing was crap. So I think the whole thing is stupid and crap. Even assuming everything Monica and them say is 100% correct, it's it doesn't make any sense to me. I don't get it. So, I understand, and then people like his work and like who he is as a person, but does that mean that Vic is going to win? Well, none of that means that Vic is going to win. I think we can agree on that much, right? And I just don't think it's there. I just don't think it's there. I just don't think it's there. And I don't think the judge screwed up enough for it to be reversed. I think the judge made mistakes, but is it enough for reversal? Probably not. I think his lawyer put him in bad position. It just seems to me it was put in a bad posture, and I don't think the appeal court's going to save him. Just what I think is true. So, sorry that's the way it is, but it's kind of the way it is. I posted something to you on Twitter. I'll check it out later. So wait, who's going after him a consensual kiss? I don't know. I don't know the answer to that question, which is part of his whatever. I don't know who mentioned it. I don't know how it came up. I don't know any of these things. It's just like so much whatever. Okay. I missed something in the case. Okay. If I missed something in the case, let's go back. I missed something in the case, let's go back. Okay. Apparently I missed something in the case. So let's go back and read it. Because I don't want to, I'm tired, but I want to get it right. So I guess I stopped writing too soon. Where's my case? I think the statute of limitations is 1 year in Texas. Here we go. Apparently I stopped reading too soon. Well, obviously it wasn't intentional. Let's see. Okay. Let it never be said. Let it never be said that I don't go the distance for people watching this channel. Let it never be said I don't go the distance for you guys. All right. Degree of fault negligence. As to the third element, whether the publication was made with requisite degree of fault, Kahn's status determines the degree of fault to be applied. Because Kahn was a private individual rather than public official, Kahn need only prove acted with negligence, which wouldn't apply here because we're in public figure status. Vanderlyn argues Kahn failed to prove negligence because he failed to offer any proof she knew or should have known the statement in question was false. The dissent voices a similar concern that Kahn failed to produce clear and specific evidence that Vanderlyn failed to investigate the truth or falsity. These both reflect correct statements of the law, but here this case's specific facts drive the analysis. Had the message stated Kahn has given money to the Taliban, we might debate whether there is any evidence in the record that Vanderlyn knew or should have known the statement was false, or whether she had a duty to investigate prior to sending the message. But Vanderlyn did not say that. She said Kahn had told her personally they had given her money to the Taliban. So with regard to truth or falsity, the question is not whether Kahn gave money to the Taliban. The question is whether Kahn told Vanderlyn that money gave analysis. This fact narrows our analysis considerably. This may split on a fact specific this may split fact specific, but if it does, I'll let you know. But the way this is being teased to me is indicating that this is going to be a fact specific thing that may or may not apply to Vic. But let's read on. This is incidentally like why you kind of have to read cases really carefully, and you have to see like the degree to which they can or cannot be analogized to any other case. Like you can't just take a sentence or a paragraph even and necessarily apply it everywhere. Sometimes, in fact, fairly often, law is very fact specific. So sometimes things turn on facts. And so when you're looking at things, you have to see like the degree to which they can read on what you're trying to read them on. But let's read on. According to Vanderlyn, she and Kahn engaged in a private conversation. During the conversation, either Kahn said she gave the money or did not say. Only two parties know which proposition is true. Because Vanderlyn knows the truth, whatever it may be, that Kahn did not say he gave the money to Taliban. And that Vanderlyn's assertion to the contrary was not only false. Let's try this again. Because Vanderlyn knows the truth, whatever it may be, if Kahn did not say that he gave the money to Taliban, then Vanderlyn's assertion to the contrary is not only false, it's made with the knowledge it was false. In other words, if it was false, then Vanderlyn knew it was false. Yes, this is fact specific. Okay, if it's false, Vanderlyn knew it was false. True, knew it was true. Either way, Vanderlyn knows the truth, as does Kahn. Under these narrow facts, any evidence that proved the assertion was false was also logically necessarily proved they knew it was false. So yes, this is fact specific. This is fact specific under these narrow facts. So what's happening here is one person is saying the other person said directly to me something. So they would know it's false or not because they heard it directly from the person. So that's why you can presume you can read in the falseness, because like I'm saying you told me this directly. Now either you told me it or you didn't. So I know if I'm saying you told me, I know whether that's true or false. So yeah, that makes sense why you could read in the falseness in that factual specific. But again, it's narrowed down. Vanderlyn argues that the same evidence to prove falsity also proved the requisite degree of false, which turns to a strict liability theory found to be inconsistent. This argument, while facially attractive, misses the point. While the Supreme Court did reject the notion of strict liability in defamation, it explained its holding to mean that the states are not free to impose defamatory liability without applying some standard of care. Stating, we hold that so long as they do not impose liability without fault, states may define for themselves appropriate standards of liability for publisher. Again, look at this language. Okay, look at this language very carefully. By holding that under the circumstances unique to this case, that's really narrow. The same evidence that proves falsity also provides standard liability. We merely acknowledge the inescapable logical conclusion that facts conclusively prove the publisher. Statement of knowledge, statements proof also shows to prove they acted with the knowledge. Thus, for the same reasons they met the burden under Chapter 27 to provide clear and specific evidence, Kahn has also satisfied providing clear and specific a prima facie that they knew it was false. It's fact specific. It's fact specific in this narrow case. Yeah. So it's fact specific. So there's no analogous situation here. The snift in their hair might be, though. The snift in their hair might be. Let me think about that. The snift in their hair might be because you're saying it happened directly to you from them, and you would know whether that's true or not. So this Kahn case might get you for the sniffed in your hair one. Yeah, I think that might get you for the sniffed in your hair, because it would be analogous, right? Vic sniffed in my hair. No, it didn't happen. So she said he sniffed in my hair and said something sexual. He says it didn't. So this might work. This might work. So this might get you where you need to be for that specific thing. Also, maybe it might get you where you need to be. Also, maybe for the jelly bean incident, because it would have happened directly to you or directly in front of you. Maybe. So okay, all right. I see the idea. I see the idea. Kahn told me personally, as opposed to he directly smelled in my hair, as opposed to I saw him do this directly. Is the fact that it's speech, though, as opposed to action, is that material? I'm too tired to say for sure right now, but I think this would work for at least some of the elements of Vic's case. I don't remember this. I sped read the brief, but I don't really remember this coming up very much in the appeal brief. But this rationale might work. I'm going to have to take another crack at it again when I'm a little bit more awake. But I see the argument. It might work. Okay. Yeah. I don't think for the investigation one. No, that does. I don't think that you can get to there, but I think you can get for things directly that maybe happened. That maybe you can get there. Yeah, maybe you can get there for the sniff thing. Yeah, maybe you can get there for the sniff thing. Now, then the only other question here, which again is a question that I'm way too tired to answer, is when you go back to this, how we all started this paragraph, we talked about the fact that it was a private individual and these were matters of public concern, or this was a private individual, but matters of public concern. And then it goes into this analysis. So for Vic, the situation is a little different because it's public figure. But I don't know that it's different in a way that matters. My initial feeling is it doesn't matter. I think you can substitute one for the other. But I'm way too tired to say for sure right now. But there's like two questions that are here that are not quite clear to my mind. Kahn's a private individual, and that doesn't apply here. So does that fact change this analysis? And then the fact that it's not a statement but rather action, does that change the analysis? I think the answer is no. It doesn't change the analysis. I think you can apply one to the other, but I am way too tired to say for sure. But it is a reasonable point. It is a reasonable point. So I'm going to take another crack at this on a different day when I'm more lucid and able to think through it a little bit more. But you've made a solid legal point. Yeah. So that might be it. But of course, then the real big problem, of course, still on top of all that is that Ty has to effectively argue that point, and so we'd have to go and so this may be an avenue. This may be an avenue, and also there's the issues of there's a couple other issues that sit on top of all this. So he presumably would have had to argue this properly to the trial court, because we discussed this earlier in the stream, the idea of raising issues, if you don't do it, you lose it. So if Ty did not properly bring this issue to the court's attention, then it might be lost. If he does not bring it, assuming he did bring it properly to the trial court's attention, if he doesn't bring it properly to the appeals court's attention, he'll lose. So now there's 4 questions. So now there's basically 4 questions. The question is, does the public figure status matter? The question is, does the fact that it's an action matter? The question, was it properly raised at the trial level? And the question is it being properly raised on appeal? But if all those things are in the right configuration, then I think you can win with this. So, good idea. Good idea. Thank you for the £5, David Youngs. Yeah. So I think yeah. So those are the 4 issues. Does the fact it's public figure matter? Probably no. Does the fact it's action? Probably no. Was it properly done at the trial level? You would have better knowledge of that than me, because you've been following the case real closely. So you would have better knowledge of whether or not it was properly raised at the trial court. I'm not aware of it, but yeah. And was it properly raised on appeal? I don't particularly remember that being particularly well brought out in the appeal brief. But if it was, then maybe it's an argument. So we'll see. So yeah, some of this depends on advocacy too. But the case does stand for the proposition that I think that you can want to get there. So good call. And then I guess there's a 5th question as well, which I kind of ignored initially, which is, I'm assuming that this is from the right place because this is Court of Appeals, Texas Fort Worth. And so I don't know how Texas does its appeals in terms of what is binding on what court. So is this case being heard by the Court of Appeals of Fort Worth? Does anyone happen to know that off the top of their head? Is Vic's case being heard by the Court of Appeals for Fort Worth? If the answer is yes, then this is binding precedent. If the answer is no, then it might not be binding precedent. It might just be persuasive. I think it's very good persuasive, but if it's not in the same court, then a different court of appeal could come to a different conclusion. So that's a 5th issue that's also lingering around. So if Vic's appeal is being heard by the Court of Appeals for Texas Fort Worth, then we can ignore that issue. If it's being heard by someone else, then we have to wonder whether or not how good this law is. And we're also assuming that this hasn't been contradicted by some other case that we're not discussing. When was this case decided? 2017? Probably hasn't been contradicted since 2017. That's a reasonably safe bet. So yeah, if does it have to be in the appeal brief, or can you bring in an oral argument? Again, this would get into Texas specific, But my assumption would be it has to be in the appeal brief. It has to be. You can't usually just spring something on in the middle of our oral argument. That's usually not proper. You have to like put it in the brief. So I would assume that's the rule in Texas too. It has to be done in the brief. So if Vic's appeal is, let's see if I can find out. Where his appeal is being filed. Well, I'm too tired. I'm going to leave it as an open question. But yeah, if it's in a different place, it may or may not be binding authority. So that's another question. All right, I'm signing off. Later, guys. Peace.